Hey guys, attorney Mark Victor here. I am the founder of the Attorneys for Freedom law firm, and we're based in Chandler, Arizona, as well as Honolulu, Hawaii. And I've been practicing law now for almost 30 years. So today, what I want to tell you about is the 5 most important things that you need to know if you're going to carry a firearm, even if you're going to possess a firearm in your home. These aren't the 5 things that you're going to get from any book. No concealed weapons instructor is going to tell you about these 5 things. These are the 5 things that I have distilled down from doing many, many gun cases over my almost 30 years of representing people. Number 1, just shut up. Now, I wish I could just say that and we could just move on. You would just accept that. But I already know from representing people over 3 decades that people don't listen to that advice. They want to talk to the police. So I started thinking to myself, why on earth do people still talk to the police after the attorneys tell them, look, just shut up, don't make any statements? Well, first off, they may forget that advice. I think it's very stressful when a police officer has been called to the scene and you're involved in a scene. So I want to give you a little bit of maybe way to remember my advice. The police officer will remind you of this advice. They're not going to say, hey, attorney Mark Victor told you to just shut up. I wish they would say that, but they don't say that. What they will say, number 1, you've been arrested. And number 2, you are being interrogated about what happened. The officer is going to give you the Miranda warnings. Now, there's 4 parts to the Miranda warnings. First off, the officer is going to tell you, you have a right to remain silent. I want you to pause and just think about that for a moment. You have a right to remain silent, not a preference, not a privilege, but a right to remain silent. This is a very hard-fought right that the framers of our Constitution put in there, and things that have been interpreted in years later by our Supreme Court. This is a right you have to remain silent. You should use it. Just will add in there as a footnote, do not consent to any searches either. Number 2, most important thing you need to know. Look, self-defense is all about reasonableness. Think about it like this. Imagine a trial on a self-defense issue. And by the way, we have tried cases here at our law firm, gun cases. Not a lot of gun cases go to trial, but we do have trial experience in gun cases, so we know what we're talking about. We've picked juries, we've asked them questions that I'm going to get to in just a few minutes here. But imagine the way the trial is going to go is all the evidence will be presented by the state, which means all the witnesses, all the statements, any video, all of that is presented. And then whatever the defense wants to present is presented. Imagine if the judge turned to the jury at that point and said, look, ladies and gentlemen, now you've heard everything, you've seen everything, you know everything, here's what we need to know from you. Did the defendant act reasonably? That's really the question in a self-defense case. You'll notice as you review statutes and look at the rules involving self-defense, that word reasonable will come up a lot. At the end of the day, that's really what self-defense is. It's considering all the facts and circumstances of whatever it is that happened in this case. Did the defendant act reasonably? And if the answer is yes, well, then you probably owe your defense attorney a nice dinner somewhere, because that means you're acquitted. The defense attorney did a good job for you. If the answer is no, well, this is very bad news for you. This means probably you're going to be taken into custody and you're going to serve some time. It's all about reasonableness. Number 3, you think it's all about the law. And it's about the law. The law is important. But your case is probably going to turn on the facts. That's right. We lawyers, we don't hardly ever argue about the law. We know what the law is. Sure, a situation will come up from time to time when maybe I'll raise a statute and the prosecutor will say, no, I don't think that statute applies, or I don't know how it applies, or we'll get into some kind of an argument. But 9 times out of 10, we're going to be able to work that out. We can find a case or something that will explain how the law applies in this type of a situation. What happens in these cases very often is I get the case and I'm representing my client and I know my client's story, and then I call the prosecutor or I meet with the prosecutor in person and I say, hey, look, I don't know why you're prosecuting my guy. Here's what happened. This happened, this happened, this happened, this happened. So why are you prosecuting my guy? The prosecutor will often say back to me, Those aren't the facts I'm working with, Mark. I have a completely different set of facts. Keep in mind, people will have good faith disagreements on facts. In other words, they may be looking at the same thing and just have seen it differently. They may remember it differently. Or people can have bad faith disagreements on facts. That's right. The victim will have a different version of events than you do. You might say, look, all I did was put my hand on my firearm and said, leave me alone, I got a gun. The victim might say, that's not what happened. He pulled out the firearm and he pointed it at me and said, he's going to blow my head off, or something like that. And if the victim has friends there, you should probably expect that the victim's version of events will be corroborated by the victim's friends. Number 4, very, very important concept for you to understand. Almost all gun crimes carry with them mandatory minimum sentences. Okay, what's a mandatory minimum sentence? Ladies and gentlemen, in my opinion, this is a huge problem with our law, something we need to change. Mandatory minimum sentences are when the legislature passes a law that tells the judge, hey judge, if somebody is convicted of this particular crime, you have to send this person to prison, usually for no less than this amount of time. I will tell you, in Arizona, the most common gun crime to be charged with when you pull out your firearm and a prosecutor says you shouldn't have done that is aggravated assault. And by the way, you don't actually have to hit another person or even touch another person to actually be guilty of assault. Assault can be just simply putting another person in fear of an imminent physical injury. Think pointing a firearm at somebody. If you point a gun at somebody and a prosecutor decides that's not a justified act on your part, it wasn't self-defense, they're going to charge you with aggravated assault. In Arizona and in most states, this is going to be seen as a dangerous offense. What that means is you're looking at a mandatory minimum sentence. The mandatory minimum for aggravated assault in Arizona for somebody who has no priors whatsoever, 5 years. 5 to 15 years with a presumptive term of 7.5. So in other words, what I'm getting at here is if you take that case to trial and you lose that case and the judge has lots of sympathy and compassion and finds lots of mitigating factors in your case, the best the judge can do is to give you 5 years in prison. Okay, number 5. Let's say you've done everything you can do and now here you are. Best case scenario, you give me a call, right? Call me up. And then I'll answer the phone and you'll say, hey, Mark, I'm thinking about pulling out my firearm. And I'm going to ask you a bunch of questions. Who are you? What is your relative size to the person who's creating the threat? And by the way, do they have any weapons? What's the distance between you? What are your other options? Can you safely retreat? It'll take me about an hour to analyze the situation. And even then, I'm probably going to give you a very qualified type of an answer. Okay, that's my final point on this. So in conclusion, again, my name is Mark Victor. I'm very easy to get a hold of. If you have questions or comments, you can hit me up directly. It's Mark, M-A-R-C, at attorneysforfreedom.com. Check us out on the internet. Just go to attorneysforfreedom.com. There are lots more videos and other pieces of advice here. I'd love to hear from you. Whether you have a compliment or a critique, as long as you bring it civil, you will get a response from me. Keep in mind and check out the Attorneys on Retainer program. Important thing to know about this program, you gotta be signed up before you have a problem, right? In order to get the discount. You don't get to first get charged with a crime and then sign up for the Attorneys on Retainer program and expect to get us at a discount. If you're in Arizona or Hawaii, you can get us on the hook for $25 a month. And if you do get charged with a crime where you're saying, hey, I acted in self-defense, all of the legal fees are entirely covered. That's right, you don't have to pay a dime to have us standing by. You're actually a client of the firm. There's not some insurance company that's going to say, look, if you're found guilty or you plead, like 90-something% of people will, you're subject to repaying the benefits. That's not the case when you join the Attorneys on Retainer program. That's because we are a law firm. And if you want to know more about our law firm, you can check us out, like I said, at attorneysforfreedom.com. attorneysforfreedom.com, and check out liveandletlive.org. This is the global peace movement that the attorneys, the pro-freedom attorneys at the Attorneys for Freedom have founded with lots of other people around the world. I urge you to be part of the solution to the world's problems, not part of the problem. Take a look at liveandletlive.org, and if you like that, hopefully you'll sign up to be a member. Again, my name's Mark Victor. Reach out with any questions or comments. Thanks so much for listening.